It's config. Okay.
Okay.
Okay. Good evening, everyone. Sorry for the slight delay. We had some technical problem. We welcome another medical legal webinar. And today we have with me Puan Fazliza. And this medical legal webinar is actually sponsored by Dr. Shil, yeah? So without further ado, we go ahead because we are already very late.
Yeah, thank you, Dr. Betty, for the introduction. Apologize for, for
No worries, no
and
worries.
all that. By the way, my name is Fazliza. This is my managing partner, Mr. JJ Chan. He has interest in medical legal matters and apparently has been conducting quite a number of medical legal cases and also reported cases as well. As for my profile, basically that would be the second slide, if at all.
So JJ is not able to join us today, I heard.
Yeah, he's not able to because he needs to attend to another call tonight. Therefore, he couldn't make it. Perhaps, like some other time. Yeah.
We'll send you the recording anyway.
Okay, sure, no problem. All right. So, can we go to the third slide, please?
Okay.
Yeah, this is me.
Yeah.
I'm the senior partner of CBE. My name is Fazliza. I've been practicing for about 19 years in practice since 2005. Prior to this, I've been practicing in Shen de la Mort, where we are representing mostly those doctors under MPS. And since I left Shen, when I joined CBE, we are dealing more with the local insurer. So we do represent doctors as well as hospital.
Okay.
At the end of the day, yeah.
Okay.
The third slide, please.
I'm sorry, yeah.
Oh, it's okay, no problem. Yeah, I should thank you actually, Dr. Betty, for assisting in sharing the screen. Okay.
Don't worry, I keep on forgetting. I'm so sorry. Okay.
It's okay. I will give you a hint.
Okay.
The law on negligence, at the end of the day, to enable the patient to proceed or to file a medical negligence cases against a consultant, there are three criteria that the patient needs to establish. Next slide, please. First of all, the patient need to establish that the medical practitioner owed the patient a duty of care. A duty of care, it is somewhat a legal obligation under the law. What is reasonable that needs to be done on the part of the consultant in order to make sure that a proper care management has been accorded to the patient. And in the event that that particular duty, it is breached and it causes injury to the patient, that's where under the law, the patient is entitled to institute a legal action for medical negligence against a particular doctor. All right. Next slide. Therefore, what is the standard of care expected of a medical practitioner? In terms of the standard of care, at the end of the day, they are twofold. One is in respect of a diagnosis and treatment cases. And the other aspect of it, it would be more on the cases involving duty to advise. Next slide. Yeah. This is in respect of diagnosis and treatment cases where Bolam test is applicable together with the qualification in Bolitho. This somewhat has been decided by the federal court in Dr. Kuppu's case. Bolam test, at the end of the day, it all depends on the opinion from a medical fraternity to confirm whether such care and management accorded to a particular patient, it is actually reasonable. Whereas for Bolitho, as long as that particular opinion can withstand logical analysis, at the end of the day, the court should be accepting that particular opinion from that particular expert in order to defend a particular consultant. All right.
Can I ask you, this Bolam test, is it decided during the court case, or is it decided when the patient comes to a lawyer and
Okay.
say, I have a case that is, I'm not happy with this doctor.
Right. Bolam actually is a test decided by the court earlier before Dr. Kuppu's case, in which I'll be doing the case analysis later.
Oh, I see. Okay, then we go on. Yeah.
Sure, no problem. Perhaps maybe I can explain now.
Okay.
In terms of the legal principle, it's still uncertain because the court basically they are quite confused whether Bolam test is applicable or Rogers test is applicable. So with the decision from Dr. Kuppu, so now the law is already set in stone where when it comes to medical negligence cases, in particular to diagnosis and treatment, Bolam test plus qualification in Bolitho is applicable. So this is the test until and unless there's a further appeal or like the highest court in Malaysia, i.e. federal court, decided to change the law, then we will be following the changes accordingly. But for now, this is the test which is applicable
Okay.
when it comes to diagnosis and treatment.
Okay,
Yeah.
because we are not familiar with it, Dr. Kuppu and his case.
Yes.
So later you will tell
Yes.
us more. Okay, great.
Yeah.
Okay.
Basically, in terms of the presentation today, it's going to be pretty short because I'll be focusing more on the Q&A. So generally, just to give an overview in terms, what is it, for us lawyers, in order for us to defend the doctors. So what test is it applicable so that, the doctors will have some sort of idea how we argued before the court in order to defend the doctors at the end of the day. Yeah? Okay, next slide, please.
Okay, this is the slide that
Yes.
may explain everything.
Okay, this is the Bolam test. At the end of the day, here in Malaysia, we still be referring to the common law cases, especially UK, because the stare decisis is binding. So this is one of the cases that we are referring to in which the federal court decided that for medical negligence cases, Bolam test is applicable. So in Bolam test, as what can be seen here, it has been decided that a doctor is not guilty of negligence if he has acted in accordance with the practice accepted as proper by a responsible body of medical men skilled in that particular art. So usually in medical negligence cases, if we are representing the doctors, what we will do is that we will be engaging an expert in the same discipline. For that particular expert to form an opinion whether at the end of the day, in terms of the care and management, it is acceptable or otherwise. So this is the principle in Bolam test. And a doctor is not negligent if he is acting in accordance with such a practice merely because there's a body of opinion which takes a contrary view. As long as both parties manage to get an expert opinion to say that my method is reasonable, your method is reasonable, at the end of the day, by right, there should not be any findings of negligence on the part of the consultant. And the other consideration that the court should take into consideration is whether that particular opinion can withstand logical analysis. So that is the other criteria in which I'll be highlighting later in respect of Dr. Kuppu's case. Okay, right. The next slide, please. Okay. In Bolitho, it was held by the English court that a responsible body of medical opinion must be capable of withstanding logical analysis in order for that opinion to be accepted by the court. So this is what that I've explained earlier. First, you must obtain an expert report, and at the end of the day, that particular report should be able to withstand logical analysis at the end of the day for submission before the court. Okay. The next slides.
Okay, we seem to have a lot of technical problem. Huh? Okay.
Okay. When it comes to the duty of advice, at the end of the day, it is actually decided by the court based on the facts finding in the course of the trial. So care management, treatment, it is based on the expert opinion, which it should be able to withstand logical analysis. And when it comes to the notice of advice, it is actually for the court to decide. i.e., whether certain facts or certain risks has been explained to the patient to enable patient to make an informed decision whether to proceed with certain treatment or procedure or otherwise. So there's twofold of it. In medical negligence, it's not so much about care management. It also involves on the advice. That also it can be amount to negligence in the event that the doctor decided not to advise properly or certain risks has not been highlighted to the patient entirely to enable the patient to make an informed decision before the patient decided to proceed further. So this is the gist of it when it comes to MedMal. One, care management. One is on the risk. Care management will be relying on the expert opinion, and that expert opinion must withstand logical analysis. When it comes to the advice of risk, it's for the judge to decide entirely based on the facts being presented in the course of the trial. So, in short, at the end of the day, for us lawyers, when we submit before the court, that's the angle that we'll be taking in defending the doctors, you know?
And this Rogers test is what?
Rogers test, at the end of the day, it must, it is for the court to decide. Perhaps maybe we can move on to the next slide.
Okay.
Yeah, this is the case, Rogers against Whitakers,
Mhm.
where it is clearly stated that the law should recognize that a doctor has a duty to warn a patient of a material risk inherent in the proposed treatment. A risk is material if, in the circumstances of the particular case, a reasonable person in the patient's position, if warned of the risk, would be likely to attach significance to it, or the medical practitioner is or should reasonably be aware that the particular patient, if one of the risks, would be likely to attach significance to it. So it boils down to the fact whether at the end of the day, before certain treatment being accorded to the patient, the risk of any injury has been highlighted to the patient. As I highlighted, like to enable the patient to, at the end of the day, make an informed decision whether to proceed with the certain treatment or otherwise. So this is actually the other aspect of medical negligence vis-a-vis on the advice of risk.
So this Roger and Whitaker, Roger is versus Whitaker. Whitaker is a doctor lah.
Yes, correct. This actually involved an ophthalmology case where at the end of the day, the doctor did not advise on certain risks that if he were to proceed with that particular injury, with the particular surgery, is going to affect his eyesight, on his good eyesight. So that was not communicated to the patient. The patient decided to proceed with the procedure, and ultimately, instead of getting back his vision, apparently he loses his vision at both eyes. So that particular risk was not communicated to the patient accordingly. So this is where here in Malaysia, we are applying this particular case when the issue is on the advice of risk. So Rogers' principle is applicable.
So this no, I find it very weird. Roger versus Whitaker is only 1992, not so far back.
Yes, not so far back, correct. It is quite recent, yes. Unlike earlier Bolam test, it was in earlier, but this is quite a recent one. So
Yeah,
that's the
before
reason
that,
why
before
at the end of the
1992,
day, earlier here in Malaysia, there's a confusion, by the High Court, Court of Appeal, or even Federal Court. So they are not sure whether at the end of the day, when it comes to the law, which test is applicable. So they just tend to use Rogers even for the care management and Bolam for advice on risk. Now, with Dr. Kuppu's case, in which I'll be highlighting later, the principle of law is pretty clear. When it comes to the advice of risk, we are applying Rogers' principle. When it comes to the care and management, the principle which is applicable is Bolam test together with the Bolitho, i.e. to withstand logical analysis. So in short, that is the law now.
No, I'm just, okay, you have this Bolam, you have this Bolitho, you have Rogers. How did the court actually take random cases? I mean, before 1992, I am sure there has been other cases where the doctors did not show or warn the patient of material risk inherent in the...
Actually, it's not a random cases. This Rogers test has been submitted before the High Court in Dr. Kuppu's case. So that's where the court imported this principle into Malaysia. And then we submitted all the way to federal court, and it become a law in Malaysia. Yeah. So it's not usually, at the end of the day, on the applicability of certain laws, it is actually depending on the lawyers, which authority that you are referring to. If the lawyers decided not to refer to certain authorities, then the court would not be looking into that particular authorities. So it is up to the lawyers on how they want to argue certain cases and which law should be imported in Malaysia for reference.
I see. This is actually a law. This
Yes,
Roger
correct.
test
Law.
is a
Yeah.
law.
Yes, it's a law.
It's not.
At the end of the day, based on the facts, then there's this decision by the court.
Oh,
where
I
the court
see. It's
decided
not
that,
just like
the doctor has a duty to warn on the material risk and what is material risk. So we imported this principle into Malaysian law.
okay, it's not just an example of a case, just a
No.
code. No, it's a
Yes.
law.
Yeah, it's a law. So that's the reason why earlier I highlighted about Bolam. Bolam is the law when it comes to care management.
Okay.
Rogers is the law when it comes to the duty to warn of risk. Bolitho is the law whether, like certain care management can withstand a logical analysis. So that is the law. And that has been, these three cases has been accepted in Malaysian court. And now when we argue, we'll be referring to these three cases.
Okay.
So the first cases that accepted this three principle is actually Dr. Kuppu's case. So that's where I'll be highlighting it later. Yeah.
Do I go to the next slide? Hold on, huh? Okay.
Yeah, so this is the case which I mentioned, Zulhasnimar binti Hasan Basri and another versus Dr. Kuppu and another. So this case apparently it started off in High Court. There's an appeal at the Court of Appeal and finally before the Federal Court. So that's where at the Federal Court stage, the law has been decided when it comes to the care management, what is the test, which is Bolam. What is Bolam? It all depends on the expert opinion. And of course, it is actually should be able to withstand logical analysis. And what is the law when it comes to advice of risk? That would be Rogers' test. And it's for the court to decide based on the facts presented before the judge. So generally, this is the case which started off the law here in Malaysia when it comes to advice of risk and also care management. Yeah. Next slide.
Okay.
Yeah. So this is a case of Zulhasnimar, where myself and Mr. Chan is involved. As I mentioned that earlier, there was a conflicting decision before High Court and Court of Appeal, because the court here not sure whether Bolam is applicable or Rogers and Whittaker's, or at the end of the day, the other one is Rogers, Bolam, and
Bolitho.
Bolitho. Yes. I'm so sorry.
I think I
Okay.
can make a good lawyer after your talk.
Right. The next slide, please.
Okay.
Yeah. So in Zulhasnimar, the federal court decided Bolam test plus
Okay.
qualification.
Sorry. Can I just ask you,
Yeah.
as this is your case, can you
Right.
give us a background of the
Okay.
clinical scenario? Because
Sure.
we have a lot of doctors here,
Yeah.
and we are, I mean, of course, I learn quite fast, so I know Bolam, Bolitho, and Rogers. But we like the little bit of, how you say, a little bit of clinical background on
Yeah.
what happened to Zulhasnimar.
Yeah.
And
perhaps maybe we can go to the next slide.
okay, see. Okay, good.
Okay, right.
Great. Okay.
This is the case where the first appellant, actually, we are referring to the mother. She was pregnant, and at the 30 weeks of pregnancy, she attended to the hospital for having abdominal pain. She was admitted, and subsequently she collapsed. And after the collapse, apparently when she gave birth to a child, the child suffered brain damage. The argument that we put forward before the High Court is this, based on the expert opinion, the doctor's expert opinion, it seems that at the 30 weeks of pregnancy, there's no indication of labor, and hence it does not warrant any emergency C-section to be performed on the mother. So that is Dr. Kuppu's expert position. Whereas for the plaintiff expert, they are saying that at the 36 weeks, since the patient now, the mother is complaining of abdominal pain, so by right, you should just go ahead with the emergency C-section. So in the course of the trial and looking at the medical records and etc., the reason why the patient, the mother, suddenly collapsed is because of the vessel rupture at the placenta. And based on the expert opinion, there's no way for Dr. Kuppu to be aware about things. No way. It can only be detected once an open surgery is conducted. So that is what the Dr. Kuppu's expert testified in court.
Okay,
And
can I ask you, was Dr. Kuppu her normal doctor that followed her up throughout her pregnancy?
yes, correct.
Okay, so she didn't just go to a hospital and
No.
say, so she went back to her own doctor.
No, she did not. Yeah, and in fact, she chooses this particular ONG to be her ONG lah at the end of the day.
No,
So yeah,
let me get this straight. So
yes,
from the time that she found out she was pregnant, she has been with Dr. Kuppu all the time.
that's correct.
Okay.
Yeah.
And then when she had abdominal pain, she also went back to Dr. Kuppu.
Yes, correct.
Okay, so correct. So she did the right thing. She had
Yes.
follow-up. She went to her own doctor and she had abdominal pain.
Yeah.
Okay.
So the issue in the course of the trial is that whether emergency C-section should be performed immediately when the mother complained of abdominal pain. So for the plaintiff, i.e. the patient's expert, they are saying yes, it should be done immediately. But for Dr. Kuppu, there's nothing to warrant immediate C-section because there's no indication of labor at that point in time. The reason why Dr. Kuppu decided to go for surgery, subsequently after the patient's collapse, the mother collapsed. So when the mother collapsed, C-sections, then only he realizes that there's a rupture at the vein near to the placenta, in which, according to the expert, there's no way for Dr. Kuppu to be aware of things. And based on the medical literature, this is actually, in terms of the ratio, 1:100,000. So in view of this particular fact, although at the end of the day, the mother did give birth to a brain damaged child, the court finds that there's no negligence because based on the expert opinion, in terms of the care management, that is acceptable, nothing to warrant emergency C-section. And at the end of the day, it will stand logical analysis as well, because no way, Dr. Kuppu, at the end of the day, he knows that there's a rupture. So in that regard, the court decided that, okay, there's no negligence.
Okay, I like to think that the ruptured blood vessel is an artery and not the vein. Okay, that's why she collapsed.
Yes,
correct. Mention a vein. I think it's an artery. Okay, a vein will ooze, and a vein is not that important. So it must have been an artery. So eventually, Dr. Kuppu was not found guilty of any negligence.
Yes, correct.
Oh, okay. So shall I go to the next slide?
Yeah, I mean, the next slide, it would be more on the facts, at the end of the day, what happened and all that.
Okay, Ken.
Yeah.
Okay.
Hysterectomy was performed as well. So this is actually more on the advice of risk because he needs to do what he needs to do. And there's no discussion, but it's more like a life-saving kind of procedure. Therefore, whether in the terms of the care management or even on the fact of the advice of risk, at the end of the day, the court is of the view that there's no negligence on the part of the Kuppu in respect of both. So that's where the court has imported the cases, the principal, i.e. Bolam, Bolitho, and Rogers into Malaysia. And we argued this all the way to the federal court. And as at now, this is the law applicable when it comes to medical legal cases.
So before Dr. Kuppu's case, do you not adopt this three law?
Because as I said, it all depends on the argument of the doctors. For us, we know for a fact that it should be Bolam. But some of the plaintiff's lawyer, they tend to argue that it's not so much on Bolam, but it should be at the end of the day, Rogers test, where the court should decide instead of taking into consideration the expert opinion. So our argument is that when it comes to risk, yes, it can be the court because that is actually fact sensitive, you know. But when it comes to the care management, so we need an expert, someone in the same field, basically to inform the court, you know what, I think there's a negligence, there's no negligence, why? And whether that reasoning is actually can withstand logical analysis. So that would be the most important thing lah.
Okay, sorry, we go
Yeah.
back to just now. So
Yeah.
you have, this is the last slide, right?
Yes, correct.
I think we have, please send in some questions, and we do have some questions.
Sure.
Now, I do agree that this is not anyway negligent because firstly, he couldn't have predicted that this abdominal pain was due to a rupture.
Yes, correct. Yeah.
And I really agree. And the mother survived, right?
Yes, the mother survived.
Okay. I think it's the bleeding that caused the child to be hypoxic, and therefore because
My understanding is that because of the bleeding, the mother collapsed, and in view of
Yes.
the collapse, there's a that the shortage of oxygen.
compromise to the supply of nutrient and oxygen to the child, so
Yeah.
that the baby actually became what you call it, suffered burst asphyxia. But it was not the delay in the treatment of Dr. Kuppu, because Dr. Kuppu, the mother survived.
Yes, correct.
So
Yeah.
there are some questions. Again, YJ asked earlier, can you explain the Bolam test? I think she has done that, but if you want, let's explain one more time the Bolam test, because we doctors, right? We don't catch this quite so easily.
Yeah, sure. Okay. Ultimately, when it comes to medical negligence cases, if we are representing the doctors and even at times the hospital, especially on the nursing side, we will be asking from the hospital a complete set of the medical record. All right. So with that medical record, we will provide the same to the expert that we have engaged. I'm going to say that, Doc, this is the medical record. This is what plaintiff is claiming. And this is what the doctors is saying based on the defense. So I will want you to study these three documentation and let me know your views on the care management of that particular consultant. So in MedMal, actually, we been relying a lot on the expert opinion prepared by those experts at the end of the day. And when it comes to the opinion, like it must be the same, what we call that, specialities. If it's an ONG cases, that we'll be looking for ONG. If it's an orthopedic, we'll be looking for orthopedic. It cannot be, oh, can you just help me or whatever to do this? No, it must be the same wavelength, the same specialities. Then only that particular expert opinion would be accepted by the court. So when it comes to Bolam, it is like, to make it simpler, is that, in order for the court to decide whether there's a negligence or otherwise, the court must be stand guided by the expert opinion produced by both parties, i.e. by the plaintiff and also by the defendant. Defendants here, I'm referring to the doctors. Plaintiff here, I'm referring to the patient. And upon considering the true expert opinion, then the court should decide accordingly whether there should be any negligence or otherwise. The most important thing is that that particular expert opinion should be able to withstand logical analysis. For example, here in this case, as per what Dr. Bharti has correctly pointed out, there's no way Dr. Kuppu were to be aware of the rupture because there's no indication. 36 weeks having abdominal pain, it did not indicate anything. So that's where the court is then guided by the expert opinion. So Bolam test is actually equivalent to expert opinion. So in short, that would be the explanation.
Okay, basically, what she's trying to say is that to strategize a court case for either party is based on one, Bolam test, whether you have expert opinion that can support what you for or against you. Okay, that's Bolam test. Okay,
Yes.
and then the Bolitho's test is where you have now brought this medical expert opinion. Do they speak logically or not? Okay, for that case that you are discussing. Okay, and then the next thing is, did the doctor actually explain everything that was needed to be explained in his consent when he's taking a consent? And that is the Rogers test. So this is basically tests or laws that they use to come up with their how you call it, their legal strategy.
Yeah, in order to defend the doctors at the end of the day.
So now we are talking about defending the doctors. Let's say you are defending a patient. Okay, is it difficult for a patient to find medical expert opinion? Because you would then have to have a doctor speaking against his own or her own colleague.
Yes. Well, at the end of the day, in fact, it's not only for the patient, even for us also, we do have difficulty in finding an expert to a certain extent, because some of the experts, they say
Can I
that,
stop share now? Sorry,
Yeah,
can I stop
yes.
share now? Okay, so I just go to the thank you. Thank you.
Okay.
And I thank you also. Hold on, I stop share now. Okay, sorry.
No, it's okay, no problem, Dr. Betty. Even like for us, like in defending the doctors, we do have difficulty as well, because as you know, like court matters, it can be dragged for a few years, and it's very time consuming. Sometimes, for the expert to be there in court, they are not sure whether am I taking the stand or the matter is going to be adjourned. So do I need to come back again the next day?
Yes,
So what's going to happen to my clinic, my patient and all that? It would be an issue at the end of the day. So it's not only for the plaintiff, but even for us, the defendants, we do have difficulty in getting a good expert. Usually, like it's actually expert to expert. And if we are aware that this particular plaintiff is, it is more like for us, like we'll be looking someone senior in that particular field. And it's not easy to get that someone to prepare an opinion. And apart from that, it boils down to the charges as well. Because like some of the insurance company, they're not willing to pay that much, like for the expert to prepare their opinion, that kind of thing. I can share here at the end of the day, by preparing an expert opinion, it can easily cost us about 5 to 10,000 one report. And in terms of the appearance in court, maybe one day attendance is going to be about 2,500. Pre-trial discussion per hours or per day is going to be like 500 ringgit. So like each and every expert, they do have their own skill fees, in which like we need to seek approval from the insurance company before we proceed with the necessary. So it is not really easy for the defendant, for the consultant to get an expert. And it's not easy for the plaintiff as well, because like there's an occasion where, like certain doctors, they're willing to go against another doctors to say that there's this negligence or whatnot. Yeah, so that's the thing. Some expert, they are willing to prepare the opinion, but they say that I will not want to attend court. So can you just, just make use of my report, but I will not want to attend court.
Is it possible?
No, it's not possible, because it's still subject to cross-examination. Like for example, the plaintiff lawyer, the patient's lawyer, still need to, pose certain questions to the doctor to say that what makes you say this. why is it you disagree? But there's this literature to say this. So there must be like some sort of like communication in court at the end of the day. So it is a bit difficult. By just merely preparing the report, it will not help. So we need someone to be there to testify in court.
So how do you think it will make it easier, better for doctors to become expert opinion? I think it's quite an impossible task. Huh?
Yeah. It is pretty difficult because I mean, like we can see, like it's for the plaintiff, we know, okay, for anesthetics is going to be this particular expert. For ONG, this is going to be particular expert. Like even like for us who are defending or orthopedic, we know there's a few is willing to, be there in court to defend the doctors. But as and when we can see new experts, but in terms of the experience, it's not there. So it will be much easier for the patient's lawyer to break their credibility or even in terms of their experience. So like the more experienced expert, the more senior ones who are willing to attend court, there will be higher chances at the end of the day for us to defend the doctors .
Because
Yeah.
you see, your amount that you pay, okay, let's say 2,000, some doctors earn definitely more than that in a day, okay? And if a person is going to court for 2,005, chances are his business maybe not so good, okay? So then the opinion, is it then a true expert opinion? Because his business is no good. Is it possible that his opinion doesn't count for much because doesn't have many patients?
Yeah. Well, at the end of the day, like for us, we do have our list of experts. In fact, recently there's one matter where we managed to get this pediatrician to be our expert. We know the trial is actually in Sungai Petani, but he's there. He's been practicing in Kuala Lumpur. The matter has been dragged for a few years, I think more than 5 years. And I think in view of the delay and all that, he did mention that, Fazliza, I think this is the last time that I'll be attending court because I will not want to do this anymore. Then I said that, what if the matters is in KL? Perhaps you can consider. Then he said no. It's just that we are representing the pediatrician. I mean, like we are representing the hospital, not the pediatrician. But apparently, we know for a fact that there's a clear-cut negligence in terms of the medication given to the child, where subsequently the child passed away.
Oh, you're so sad. And
So
you represent.
So in fact, that's the first child of that particular mother. So we had discussion with experts and that kind of thing. And after this session, the mother went to the expert to say that, thank you very much for your explanation. I've been waiting for so long to know the truth. No one is willing to let me know what happened to my child. Now I know, because of medication. It's not so much about bacteria acquired in the hospital and that kind of thing. It's not so much about the allegation or the nurse's bath, the baby, in the sink or whatever, that it causes infection. So there's more to it. So with that,
They want a closure, right? Not the...
correct. So with that, like the patient went over to thank him. So like it really knocked some sense into that particular doctor lah. Maybe perhaps I should.
He did some good. The good
Right.
he didn't see the good that he could do.
Right.
And then when
Yes.
he did the good,
Yeah.
and the mother came to thank him, he then opened his eyes to say that, oh my God, my effort suddenly is so huge. Okay,
Yes.
Dr. YJ asked, when the court is assigning the judge for court cases, will they assign judges who specialize in medical cases? Is there something like this in the legal field?
No, actually, when it comes to the assignment of cases to High Court judges, it's actually on rotation basis. So we would not know it's gonna be before we judge or whatever. So we just need to argue accordingly. So that's the reason why at the end of the day, as per what I highlighted, when it comes to MAPMEL, expert opinion is really important. In which Bolam test is applicable, where the court is then guided by the expert opinion. When it comes to the advice of risk, as I said, that is more the facts finding. What did you inform the patient? Did the patient basically understood in terms of the risk to enable. So that is more fact finding. So there's no such thing as, like this particular judge has a second degree in medicine or whatever, therefore he'll be hearing these medical negligence cases now. No.
No, huh? Okay. So basically, they are a judge for anything and everything, lah. Okay.
Yes.
So again, Dr. YJ, can you share how the lawyer of the patient counter your argument during a trial? The lawyer.
Actually, it's more on the, as I said, it is more on the expert opinion. When it comes to care management, it's very technical. For example, when it is more on the advice of risk, so that the main thing it would be, let's say on the consent, like how did you explain to the patient? What's the process? Like, are you sure that the patients really understand and that kind of thing? What makes you think that, like that the patients understand, although at the end of the day, there's some sort of like signing, because the patients tend to argue, yeah, even I sign, but at the end of the day, I don't know. I know like the doctor did not explain, like I'm a Chinese, doctor is Malay, then the nurse is Indian, so there's a lot of miscommunication, so I don't really know. So it says sign, I just sign, and that kind of thing. So our argument, is going to be, yeah, now you are saying this, but at the material time, like you did not really indicate that, if I were to know that this is the risk, therefore I will not proceed with the procedure. So our argument going to be like it's an afterthought. So the patient, at the end of the day, it is more on the fact that consent, advice of risk. Care management is a bit hard to argue, it's very technical. So they'll be harping more on the entry in the medical record. Like certain things has not been recorded, but your expert says this, then how? Like that kind of thing. So on that aspect of the expert opinion, the entry in his medical record is really important as well. Because sometimes, like certain questions being posed, the expert's going to say that, Faziza, I'm not in a position to answer to your question number 1 because there's no such entry. Same for number 2 and number 3. Because at the end of the day, when they are in court, they need to defend their report. And if certain information has not been reflected in the medical record, it's a bit difficult for the expert to defend. They cannot be saying that, oh, I assume I had this discussion with a particular defendant. Usually we tend to we would not encourage our expert or even like the doctors that we're defending to have a discussion with the expert. So if any discussion, it should be through us. We will filter like in terms of the the questions, documents and all that.
Okay, we need to go on. We have a lot of questions actually. But actually, just let me add on that where he said, oh my God, we got so many questions. Okay, how the lawyer of the patient counter your argument? They actually don't counter the argument just yet. They put the witness, because I've been in the court myself, they put the witness. So one person will ask all the questions, then they will come and ask other questions to it's quite tough, quite stressful for me.
Yeah.
Can you share, hold on, Dr. Kamala asked, was any CTG done for the patients?
Yes.
So
For that.
before the surgery, was the CTG showing any fetal distress?
No, in fact, no. It's just that the consultant decided to proceed with the C-section after the patient's collapse. That's about it.
Okay, so the patient came with abdominal pain. What was the time of the duration between coming with the abdominal pain, seeing the doctor, and then she collapsed? And this collapse is, what do you mean by collapse? Did her blood pressure drop? Did she just what is the term collapse?
Okay, the patient came to the hospital in the morning. So the incidents where she collapsed, it is actually at night.
Oh,
so there's a difference of more than 7 hours, for this particular condition to basically to happen. Collapse meaning that all of a sudden she just fainted. So that's the definition of collapse.
She lost consciousness, maybe because blood pressure was very low. So in that 7 hours, TTG was done, there were no fetal distress, there were no signs of labor, no reason whatsoever to go into emergency seizure. Okay. So Bruce Lee asked, why was emergency seizure not warranted at 36 weeks? No. Okay. The mother did go for emergency seizure when when the mother collapsed. Okay, it's just before that she collapsed at 7 hours when she was in the hospital. Nobody did think that they didn't go to seizure because there were no indication to go into seizure. Okay, let me answer that. Okay, Dr. Kama asked, is it fair for the doctor to decide for the doctors? What if the evidence is not sufficient? Okay, this is
If the evidence is not okay, usually when we obtain an expert report and the expert says that it's defensible, we will defend the doctor all the way. And in the event that the report says that I think there's some sort of mismanagement, the first thing we'll do is that we will communicate with the doctor. Doctor, this is the report. So what do you think? Some, they just tend to accept if that particular expert is much more senior with experience, well-known and that kind of thing. Some, they are saying that I don't think that I'm in agreement, certain aspect of it. Why don't you seek second opinion? So that's where we will advise the insurance company that, you know, the insured, the doctor will want us to seek second opinion. So like we will look for the second opinion and to see whether the second opinion would say otherwise.
okay. Is there a case where the doctor admit that he is wrong and then settle it out of court? And if it's settled out of court when the doctor is admitting to wrong, will the insurance pay?
Okay. Usually, for those cases that we are handling, in the event that we are resolving it out of court, it is always without any admission of liability. We never ask our
Of course, yes, but in the sense that the patient will get some form of monetary.
Yeah.
Yes.
Usually they'll pay because at the end of the day, there's no point to proceed with the trial if liability is apparent. Then, you know, like for no reason, we're going to slap with costs, with aggravated damages, with interest and all that. So might as well just cut the losses lah. Yeah.
Yeah.
Yeah,
Okay.
because, you know, like if you were to proceed, then there's always room for other parties to appeal, either to enhance the damages or to appeal on the liability. If you were to settle the matter, then it ends there. Because like it is with consensus of both parties, like this is the amount that we are happy to settle and this is the amount that the patient is happy to accept.
Okay, YJ, I ignore you first. You asked so many questions. Okay, wait. Dr. A asked, won't there be any bias when you get the expert maybe from the same fraternity? Possible. I think very possible.
Not really, because like usually if that particular doctors, I mean like the one that we're defending, they're actually practicing in KPG Group Hospital, then maybe we look for someone's practicing in Pantai Group Hospital. You know, like we try to get doctors practicing in different state instead of the same state.
But this fraternity, our fraternity is not that big, you know.
Yeah, I know. So that's the reason why, like, sometimes when we approach, then that particular aspect gonna say, you know what, Faziza, I think I know this particular doctor, so I'm not too sure whether it's gonna be an issue. You know, at the kind of day. Then I will ask him that, do you think it's gonna affect your opinion, whether it's gonna be biased or otherwise? Then he said no. Then if that's the case, I say that I trust you lah. You know, at the end of the day, as an expert, you really want to defend your report. And in the event that you know, like throughout the trial or midway of trial, you decided to retract to say that agree, then it will not look good on you as well because it's going to be reported in the law journals. And that's where, you know, sometimes the judges will make a remark, this particular expert is not really a good expert. So from there, you know, like in a way, it will tarnish reputation as well lah. So usually for those who are expert that we engage, we make sure that they really can defend that, you know, instead of just doing it for whatever reason, not so much in defending the doctors at the end of the day.
Dr. Ahmad Kamal asked, why don't the legal fraternity accept Hippocratic Oath as a form of statutory declaration or sworn statement? I don't understand this statement. So we will pass this one first. Dr. Faiz asks, what is your opinion about ADR for medical negligence versus medical litigation? What's ADR?
Is it like arbitration, dispute resolution, something like that? I believe so. Okay, nowadays, right, at the end of the day, when it comes to medical negligence cases, the court would always want parties to mediate. At
Oh,
times,
that's good.
to go for mediation. It's just that at times, you know, like for us, certain damages, there's certain certain injury, there's certain damages that the court has awarded. So we are stand guided with that. You know, like for example, I did mention about Bolam and all that. That's more the legal principle. But when it comes to certain injury, it's really been codified. Like if you, like having a loss of vision. So under the Bar Council Compendium, this is the amount. Then the case authorities, this is the amount. So sometimes when we assess the damages, we tend to be very reasonable. We did not take into consideration, like for example, interest or even the plaintiff's lawyer legal fees. So we propose a certain figure. But for the plaintiff, at the end of the day, they are looking at a different angle. Like they will want, I will want this, I want that. Hence, that we cannot reach into consensus. So
Yes. Hello? Can you? Is it me? We hang. Hello? Guys?
It's her, it's her.
It's her?
Yeah.
A lot of
but Saturday is more on the issue of the
Hey, sorry, we lost you for a while. Okay. Okay.
Yeah,
You know
right.
what is ADR, Dr. Faiz? Maybe you like to Dr. Faiz, maybe you would like to tell us what is ADR. Are verbal consent acceptable in the court of law, especially in emergency surgery?
Well, at the end of the day, there must be some sort of indication as to why certain consent being obtained verbally. And when something is verbal, it is always subject to counter argument. Why was it was not recorded and that kind of thing. Like for example, like I just attended one matter recently before the Court of Appeal, where it involved a delivery, where subsequently the baby suffered shoulder dystocia. So in the course of, we managed to defend that particular doctor in the High Court, and the plaintiff decided to bring it further to the Court of Appeal. That's the issue that the Court of Appeal is a bit perplexed is on the maternal exhaustion, where in the course of the trial, we managed to get an expert. The expert says that it is more on the observation of that particular ONG to decide whether there's a maternal exhaustion or otherwise, and therefore she decided to go with vacuum delivery. But the mother is saying otherwise. Mother said no, I'm still okay, even like it's more than 10 hours.
What happened to the baby?
Apparently she's having a shoulder dystocia.
Oh, I see.
Yeah. So the argument before the Court of Appeal is that there's no notation on the part of the ONG to state that there's maternal exhaustion that warranted her to proceed with vacuum. So my argument before the Court of Appeal is that at the end of the day, that was the facts adduced in High Court and the expert has accepted. And the trial judge did hear the evidence from the mother. So if the panel were to ask me the same questions over and over again as to why there's no notation, I cannot say for a fact because it happens a few years back. Those days, in terms of the entry, is not so good like, compared to nowadays because like now everyone tend to be very about, MacMel, so they tend to make a very comprehensive notation otherwise. Therefore, it boils down, on the issue of consent, it's going to be the same thing as well. If it's not recorded and it's only verbal, it's going to be an issue. Because when it comes to trial, patients tend to say other things. And it's going to be like your argument against my argument, your words against my words, and it's up to the judge to decide.
So the doctor lost the case?
We managed to defend at the High Court, and it is pending before the Court of Appeal.
Oh, but I
Yeah.
think that it's the judgment of the doctor, right? If in this
Yes.
case,
Yeah, that's our argument because there's no
it's the
notation and
doctor's
the expert
judgment.
agrees. And
Yes.
after hearing the evidence from the witnesses, the trial judge is of the view that, yeah, I can accept that particular
The
opinion.
doctor's judgment is not And this judgment, this acumen, is something that somebody that we actually it grows in us with experience. And we
Yeah.
can't tell you. We know that you are exhausted. If we don't do something soon,
Yes.
okay, you'll be suing us for something else.
Right. For brain
Something else
damage
that-
and
yeah, that's right.
neck.
It is the doctor's judgment. Okay, it's just too bad that the child had this dislocation, but I think that that cannot, I mean, cannot be faulted, because sometimes you look at the patient, you know, especially let's say a child, okay, it's very sick. You need to do something right now. And something that you need to do can, let's say it has to be something drastic. Okay.
Yeah. But my
Uh,
issue is that there's no notation. So the Court of Appeal is wondering,
no, but
why?
sometimes you
So why
can't
should I
even
trust you? Why should not
you
I
have
trust
to
the
do
mother?
any,
So what's so special about
yeah,
you?
unless you have to back, I mean, retrospectively, you go back and write in your notes, okay. Okay.
But the explanation is that everything is fine. So why should I be writing all that? That was the argument of the doctor lah. At the end of the day, that's a defense lah.
Documentation is extremely important, I feel. I
Yes.
think to all the, if you don't learn anything today, learn that documentation is extremely, extremely important. I write everything, every single thing. How to protect the doctors. If you explain well, patients understand well, if a thing went wrong. Yeah, how to protect the doctors. Why you want to protect the doctors? Why aren't you asking why not protect the patients?
I mean, at the end of the day, as I said, as per what Dr. Betty said, the notation is really important because in terms of the timeline, there are about 6 years for the patient to institute legal action. So, like maybe you have the view that, yeah, everything is fine, that kind of thing, but 5 years down the road, everyone be lying in that documentation. And even for the experts also, in order for them to, like to form their opinion whether there's a negligence or otherwise, we will rely back on the medical record.
Yes.
So in a way, in order to help the doctors, to defend the doctors, I believe the notation, the medical record is really important.
Yes. It's
I
not how to protect the doctors, how you protect yourself. Okay. You don't want to protect, you don't want to do too defensive medicine. So you protect yourself by being diligent, being conscientious, write everything. Okay. For example, why do you do this? Explain to the patient, even if something went wrong, because sometimes it does go wrong, explain to the patients. They will understand. Okay. Is there a possibility amongst the colleague that a doctor giving expert might be swayed to give a favorable opinion when it's clearly there's a negligence? Dr. Kate, yes, who asked?
In a way, yes. Usually in a situation where we tend to seek second opinion, and we will, in that regard, usually when it comes to second opinion, it is actually the doctor who needs to pay the fee on that report.
Oh, I see. So when a expert opinion gives it not in his favor, he will ask to give a second opinion.
Yeah, correct. Meaning that we will look for a second expert because usually the stand taken by the insurance company is that what makes you think the second opinion would be different from the first opinion. So they are always of the view that if one opinion say that the doctor's is negligence, then for sure second, third, fourth is going to be negligence as well. So under that circumstance, if the doctor decided to engage or would want us to procure second opinion, that cost in obtaining that report, it should be borne by that particular doctor.
Okay. So can I ask you, that this second opinion, seeking second opinion, the first opinion or how many ever opinion does not need to be made known to the patient, right?
Usually, no, we won't. But to certain extent, at times, the patient's lawyer, they are aware. sometimes
they are aware.
yeah, maybe I don't know, maybe like when we engage whatever they've been sharing, like I've been approached by this is the matter. So sometimes like we are quite surprised as well. I mean, as to why, like the patient's lawyer is aware which expert we approach and and that kind of thing lah. But not all the lawyers lah at the end of the day, it's just some of them lah, in view of the connection or whatever, I suppose.
Yeah, I
not sure.
think so. I mean, is people talk all the time.
Yes,
It's
correct. Yeah.
okay. I think we had a long Q&A today. Quite interesting. So you represent only doctors?
I represent both doctors and hospital as well. So depending,
Oh, but you don't
Right.
represent patients?
no, we are not.
Oh, you don't represent patients. That's sad. You should.
No, I mean, it's a bit difficult. I mean, we decided if we defend, then we defend all the way, whether doctors, clinics, hospital. So we are not going to switch caps at the end of the day.
Oh, okay. So when you represent doctors, these doctors are from, okay, for example, in Dr. Shield, you can choose any of your lawyers, but you a panel with other,
Yeah, we are the panel for most of the insurance company lah, who's, like having this MedMal scheme. Yeah.
okay.
Mhm.
Okay. So maybe one day you will represent patients. I feel like it's an important part. Opposite of PS Ranjan. Yes, opposite of PS Ranjan, but PS Ranjan also can represent doctors. Let's say you take you buy indemnity insurance from Dr. Shield and you decide to engage PS Ranjan as your lawyer, is also possible because Dr. Shield allows you to find your own lawyer, and I think that's very important because not all lawyers not all doctors are made the same.
Yeah, correct. I mean, we do have matters as well where at the end of the day, like our firm and also PS Ranjan, we are representing the defendant to the other side of the camp instead of they are for the plaintiff lah. So at times,
PS Ranjan also started off representing doctors.
yes.
Then yeah, but there's good and bad, and I think I've been in court as a plaintiff suing a doctor.
Okay, that's
And
interesting.
yeah, but I would never want to be in court as a defendant. It will be too stressful, and I've never been in court being a defendant. Okay, see you guys. Thank you very much, Lisa. Maybe next year we can do some more talks.
Yeah,
Yeah.
sure, no problem. Thank you
Maybe
for
we can
having me.
get JJ to give a talk also,
Can, sure, yeah, sure. We can arrange for something. Yeah.
because this year it's all been full already. Bye,
Yeah.
guys. Okay, sorry, guys. Next next week, there's no webinar. There will be no webinars for 2 weeks. I fly off to UK. My daughter is getting married. So, so see you guys. Bye. So when I come back, we'll have a webinar. Yeah. Have a good week ahead. Yeah. Bye.
Right.
See you. Okay, can go. Thank you. Thank you. Bye, guys.
Thank you.